Welcome back. Perspectives in Child Maltreatment. In Module 8, we will be looking at forensic interviewing and legal issues. So right out of grad school, I spent 4 years working as a forensic interview specialist and therapist at a child advocacy center. These were very formative days, very memorable days, very challenging days, and I look forward to introducing you to the field of forensic interviewing. I did not know about the field until I got hired for the job. I applied for the position because it was listed as forensic interviewer and therapist, and it sounded interesting. I knew it was working with child abuse intervention and child abuse prevention, and I had done a fair amount of research on the topic. We'll also be looking at legal issues, and I wanted to pair these two ideas together because when you're talking about forensic interviewing, you're talking about legal issues in child maltreatment. The entire purpose of a forensic interview is to create a legally defensible investigation for the child's best interest. We're not trying to prove that abuse happened as much as we are trying to find out what happened. And if the truth of a child's allegation is that they weren't abused, we are independent fact finders and want to find that. So let's introduce you to the field of forensic interviewing, and then we will get into the second part of this conversation about legal issues. So forensic interviewing is defined by Steele as eliciting information from a witness for use in a legal setting. So usually when we're talking about forensic interviewing, most commonly, especially in the context of this class, we are talking about child forensic interviewing, interviewing of children who are suspected witnesses to crime or suspected victims of crime. So in those 4 years, I conducted almost 600 forensic interviews. These abuse scenarios that led to the interview ranged from anything to a child thinks that the child's witnessed domestic violence, child's witnessed the production of methamphetamine in a meth lab, and investigators want a child-friendly way to elicit information to aid in their investigation. To allegations of physical abuse, and most commonly allegations of sexual abuse. So I found that on a typical day, I may interview 2 to 3 children who had some previous statement indicating possible abuse. Usually this is to a teacher or a parent who then refers to DHS, who then referred the case to our agency. And so we only took referrals at the time. This was in 2001. We received referrals from DHS, from law enforcement, from a prosecutor's office. Those are our 3 main entities. And so that was the majority of these cases that we took. So a part of the context, and I'll explain this as we go, but the social worker, the prosecutor, the multidisciplinary team was invited to observe this interview. So whoever was the referring entity, whether it was a social worker, at the time we covered it in 6 to 8 different counties, a really large swath of area. And so social workers from all over that area would come in. We would meet the child at the time of the interview. So we did minimal information interviews. So we did not have a lot of information. We had the statement that led to the primary disclosure. So sometimes the social workers would initiate their investigation, and this would be a really quick confirmation that the child made the statement. And so then the DHS worker, or at the time, that's what we refer to them as, but the CPS worker, social worker would then bring the case in. They would sit in an adjoining room that was was fed with closed caption television, so they could see a live feed of the forensic interview. And then at some point they could feed questions to me as the interviewer. This was usually towards the end. So I would let the child know that I have friends watching. I would introduce them to the camera, to the environment, to my job. I would say, my name is Mr. Keith. My job is to talk to kids. And today you and I are going to talk. And then we'd get started. So let me give you the history of forensic interviewing. So I began my career in 2001. And the field was about 20-ish years old at the time. And so on my first day of training, we went through the history of forensic interviewing. And then I went to additional training in Minneapolis, and I learned about these daycare cases that really were the impetus for the creation of the field. And so I'll let you know what was told to me. This is the foundation, historical starting point of forensic interviewing. So in the 1980s, states began changing laws and making it easier for children to testify in court. So the court is set up in an adversarial setting, and children are often the only witnesses in cases of alleged abuse. So it's imperative to have testimony if prosecutors hoped for a conviction, as Martin notices and brings to light in 2010. Now, uncorroborated testimony is problematic. It's one person's opinion against another's. And so laws have changed to allow a statement that is not supported or confirmed by additional evidence or authority. So what this means is that laws have been enacted to give victims greater, or we would say alleged victims, greater ability to make their statement known, make their experience known. The courts have validated this effort. So probably the beginning happened in 1983 with the McMartin Daycare case. Virginia McMartin was a woman who created a child care facility. She created a daycare and employed her relatives. So Judy Johnson was a woman. She dropped off a 2-year-old son. It is important to note that she had a history of mental illness, although this certainly would not inhibit someone from putting their kids in daycare. But Miss Johnson eventually accused the daycare of abusing her son. Miss Johnson's firm belief created suspicion, so she went to law enforcement and made these pretty intense claims. And in time, this would lead to claims and allegations of ritualistic abuse and cult participation. Now, in context, in the 1980s, there was a huge fervor around heavy metal music, and heavy metal music was deemed to be satanic. And if you were listening to heavy metal music, it's quite possible that you were in the occult, and then quite possibly you were ritualistically abusing children. And so we have to look at these events in their historical context. Mrs. Johnson's accusations were primed in a time that had danger and fear, and the media just really fell hook, line, and sinker. And then also the police department and the local investigating agencies fell hook, line, and sinker. You know, they're probably very well intentioned, these police officers. They wanted to stop child abuse, as you and I do. But their tactics then became problematic. And it was really this case that showed the reality that we can't help children if we're not helping them in a legally defensible case. So Ms. Johnson had a firmly held suspicion. This led to misleading interview questions. So these became very heavy-handed. Law enforcement officers were already convinced that abuse happened, and they would go to all the children in the daycare and say, little Johnny told us that he was touched wrongly by this person that works at the daycare. So tell us how they touched you. It's a very, very misleading question, right? It almost presupposes that we know that you've been touched or your friend's been touched, and we know you got information and you're coming clean. It was almost like if you apply the dirty, hairy investigative techniques of the 80s to children, then this is what you get. And it was very, very problematic. Kyle Zerpolo, then a student at McMartin Daycare, later confessed to lying under oath due to the intense pressure felt by adults. So you have a child anywhere from 2 to 6, and he's getting investigated by the police. In his mind, he's about to go to jail. So he's going to tell them exactly what they want to hear. And many of those who were falsely accused never recovered. So this case went to trial twice with 2 hung juries. Millions of dollars were spent in order to resolve this case. And in hindsight, we saw serious, serious problems with the system. So to discuss forensic interviewing and to discuss these court reforms and this reform of child interviewing, we have got to talk about suggestibility. Suggestibility is the accepting or acting on something that is implied by a person. Now, all people are suggestible. You and I are suggestible. Some are more prone to this than others. But the frequency of misleading questions trips us up, and we can do this in our everyday life, right? We can assume some certain things, and so what the forensic interviewing community that was just first beginning, child advocacy movement really began because of this case and similar cases. It would be important to create protocols whereby we will not ask biased questions or leading questions or misleading questions. So an unbiased question is a question worded in such a way so as not to influence the respondent's answer. So as a forensic interviewer, if there was an allegation that the child was touched inappropriately by the uncle, I definitely would not begin the interview saying, "You're here to talk about what your uncle did." All right, that presupposes that they actually were touched inappropriately by their uncle. So we would really begin with rapport building. Hello, my name is Mr. Keith. I talk to kids about all kinds of stuff. Today we're going to talk about family. So let's find out about your family. We would draw pictures of their family, and then that would be a kind of an orientation from my standpoint of their developmental ability, their linguistic ability. Also, I would have information about who might be in the residence, and so if that's lining up, then that would just confirm things. Sometimes kids were just ready to get this over with, and sometimes they would, older kids specifically, 8, 9, and 10, sometimes would almost spontaneously say, "Well, my uncle doesn't live here because my uncle, he did some things that were bad." And so an open-ended question would be, well, tell me about the things that he did were bad. All right, that's an open-ended question. And I would only say that if the child already previously acknowledged the abuse scenario. So it was really important. Never introduce the child's information that you might know from the front end. Cannot influence your questioning. It must be unbiased, and you must be able to prove in court that you provided a legally defensible interview that was not preying on a child's suggestibility. You'd also have to be prepared to go into court and talk about children's suggestibility. That I would say in court that children are suggestible, but not any more suggestible than you or I. That's almost a matter of personality. Now, in terms of age, what we need developmentally appropriate questioning. We need questioning that kids understand. And so we have protocols to sort of help set us up for this. So through the McMartin daycare case, we also discovered that repeated questioning is very negative for a case and is very negative for the child's emotional outcome. On average, a child involved in an abuse investigation will be interviewed 11 times. That was from research conducted in 2006 by London. Repeated questioning implies to a child that they did not answer correctly. This is the trickiest thing because in the process of disclosure, children oftentimes disclose in a process, right? So they don't give us a 8.5 by 11 10-page well-dictated paragraph form of this scenario that would help us in an investigative. They are kids, and they are going to usually speak in a developmentally appropriate way. So we would expect that 8 and 9 and 10 and 11, 12-year-old kids will all communicate differently than a 3, 4, or 5-year-old child. Older adolescents, 17 and 18, will communicate differently. But the biggest thing is that we don't want further trauma to be placed upon the child. That was really the heart, is we want kids to be able to tell their story. We want kids to be able to communicate their real experiences. And we want to provide an environment that's emotionally safe and age appropriate and culturally appropriate. So repeated questioning can produce uncertainty, and it can implicitly communicate that the child is not answering correctly. It hinders the legal defensibility of the interview. Tremendously it does. So this was always something that we would try to be mindful of, that and in time you can be skilled at this type of interview process. When you're forensically interviewing children 2 or 3 a day, 4 days a week, sometimes 5 days a week, you can be skilled at this. And so it's important to have good supervision. It's important to have a good team around you to help you get better. And so there's different tools that a forensic interviewer will use. One of them is the anatomically detailed doll. Back in the 80s, when these first began to be used, they were referred to as anatomically correct dolls. So anatomically detailed dolls are dolls with anatomical details designed to allow children to provide details concerning an abuse scenario. So I would introduce these by saying these dolls have all their parts like people, and we use these to help us talk with kids about touches that they don't like. Now, I would be careful not to use these anatomically detailed dolls unless a child has already made the abuse scenario. So if we're 25 minutes into an interview and the child discloses, and then they're disclosing these details, sometimes it can be very difficult to gain clarification from a child in a legally defensible way. So these are used for clarification and demonstration, not for diagnosis. We don't walk into a a school of kids and take the anatomically detailed doll and rip the pants off and say, he's got his parts just like people. Now, raise your hand if you've been touched inappropriately. You wouldn't do that for several reasons. So this kind of use of anatomically detailed dolls are beneficial only if you've been sufficiently trained, if you're being sufficiently supervised. We went to specific training that dealt entirely with correct use of anatomically detailed dolls, and we went to these trainings a lot. And we had supervision in-house, and sometimes went to supervision off-site. And so we worked really hard to use these correctly, because the whole point is the child can tell their story, but if it's not legally defendable, then it won't help them. So anatomically detailed dolls are useful. So they're usually used only with specialized training after disclosure of abuse has been made. So it is essential, even before the use of dolls, before the discussion of an abuse scenario, to develop rapport. This is the first thing that must be done. Warren et al. In 1996 found that many interviewers never built rapport. So rapport means it's child-friendly, it's age-appropriate, it's culturally appropriate, and the child must feel that you genuinely care about them. As a man, I found one thing that I had going against me was most parents, if I was interviewing a young girl, most parents assumed that their daughter would not come back with me. Many times these were young girls who had displayed fear of men, and for good reason. A lot of them had been abused by men. And so for me, I felt there was an extra measure of concern that I had to display, and an extra measure of compassion and child friendliness, and just being professional but also engaging. I would walk out into the waiting room, and I'd have to be confident, but I'd have to be friendly, and I'd get down on one knee, and I would look at a young child, and I would talk directly to them. I wouldn't really talk to mom, because the child is child focused and child centered, and I would say, hello, Mom, my name is Mr. Keith, and I talk to kids about all kinds of stuff, and you and I are going to talk today. And so, Mom, we're just going to go into the back, and we have some friends who will be watching, and I may or may not say that on the front end. But I got to be pretty proficient at getting children to feel as though they wanted that we wanted to hear their story, and we cared about them. And that's the heart of child abuse intervention and prevention. It must come from a heart of genuine concern for the kids. There needs to be some establishing of rules. So some of our rules is, if I make a mistake, then you just correct me. And that communicated in a courtroom that we wanted to be corrected. We did not want to establish any suggestibility whatsoever. And we could use that in court if a defense attorney, and when a defense attorney did accuse forensic interviewers, and in my case, when they accused me of being suggestive and leading, I would come prepared, and I would say, well, actually, at 15 minutes into the video, you can see that the child corrected my use of their uncle's name. I had said their uncle's name incorrectly. I just made a mistake. And the child corrected me with the pronunciation, and I said, excellent job. Thank you for correcting me. So we would reinforce the fact that we're not omniscient. And sometimes, 2.5-year-old, 3-year-old, 4-year-old kids are very egocentric, just kind of the leapfrog of Erik Erikson's research, that they think you understand exactly what they're saying. If they talk about their friend Jimmy at daycare, they will just say, Jimmy, me and Jimmy. And you're supposed to just know, because adults know. until they don't. And so we have to really be intentional as forensic interviewers to reinforce they're correcting us. That's part of the rules that we would establish. Also, I would say when we don't play or pretend here, that communicates to a jury and to a judge and to a defense attorney that this is not playing. And I would say after a child had made a disclosure of abuse, and I got as much information as I could, if I used the anatomically detailed dolls, I would introduce them. I would say, these help us talk with kids about touches that they get that they don't like. And I would use their languages, whatever words they would use for their own anatomy, I would use those words. If they used their own slang to talk about the sexual acts of sexual abuse, I would use those. And so that really creates this idea. I am not driving this discussion. They are. Their abuse scenario is driving the discussion. I'm facilitating it because I have some knowledge in how children talk, how they think, and I had the privilege and the responsibility of being called as an expert witness on child forensic interviewing 10 to 15 times. One of these cases was argued before the Mississippi State Supreme Court, and my interview held up under appeal after appeal all the way to the Mississippi State Supreme Court. More on legal findings. So a child advocacy center is usually where the forensic interviewing will take place. This is a center designed to assess allegations of maltreatment, to treat victims by enlisting a multidisciplinary team of law enforcement, medical evaluators, social services, legal and clinical professionals. And the multidisciplinary team is vital. We had regularly scheduled MDT meetings. I served on those. That was a big part of my job. We actually had a multidisciplinary team coordinator who kind of helped facilitate these meetings. So that individual and myself would routinely be at these meetings. I was blessed and fortunate to receive an award on 2 occasions from the multidisciplinary team. And I say this just because I could not have done my job without the team. The forensic interviewer needs CPS and needs law enforcement, and vice versa. We all play a role, and if you don't have one, then children suffer. So a forensic interviewer has to be competent in several areas. You have to understand child development. You have to understand linguistic development. Interviewing a 2.5-year-old and a 3-year-old is much different than interviewing a 17-year-old. We must have trauma-informed practice. Any therapy that takes place, and even the forensic interview, has got to be informed about the impacts of trauma. Psychotherapy and family therapy, if it does not happen on site at the advocacy center, which usually it does, there needs to be a strong referral network to the best mental health therapist who has been trained, who can provide trauma-informed practice. And then also, the forensic interviewer has got to be competent with social work, counseling, victims assistance, law enforcement, child medical evaluation, and the multidisciplinary team. And I think this is a natural segue to the legal system. So I'm going to try to just facilitate this discussion and continue on seamlessly. Our U.S. court system, as I mentioned earlier, is adversarial. It's a system that involves active and unhindered parties contesting each other in the presence of an independent decision maker. So this independent decision maker, usually a judge, often involves a jury, and it includes cross-examination. This is questioning of a witness by the opposing party. So this sets up children in kind of a situation that they lost for years and decades and even centuries. In an adversarial system, you have a weaker opponent. And by weaker, what we mean is they're younger, they have different developmental abilities, they are at a different place, and this is victimization by definition. Victimization is taking advantage of a weaker opponent, someone who is vulnerable, and this is why we're in the field, right? We're in the field to prevent victimization. And so these reforms that have been taking place since the 80s have seen the value that children provide. Children provide a tremendous value to the legal system. And I mean, we hate to see children victimized, and we hate to see them dragged into court, but they are competent witnesses when they have a team of people to help them, and their unique needs need to be understood. So courtrooms can be confusing, even traumatic. So child preparation is key. In fact, research shows that when children are prepared sufficiently, they provide more accurate testimony, and they're less likely to be traumatized. So there's a national program of court preparation group, and it's a national program that prepares groups of children for court through education, role play, and even touring courthouses. So those running this group can take a group of children who are scheduled to go to court to testify for a variety of reasons. We simply take them to the courthouse. We take them and let them see what the courtroom looks like. We even will use role play to prepare them emotionally. In fact, researchers have found that this tremendously helps. Cross-examination is a harsh reality of our adversarial system. Now, fortunate for child advocates, defense attorneys, I think, realize that if they just bully a child, if they just harass a child, this is not going to look too good to a jury. So they usually leave their harshest attacks to folks like us who are child advocates who are testifying. So the CPS workers, law enforcement agencies, and myself was oftentimes listed as an expert witness in child forensic interviewing, and so I would get it from defense attorneys. And I might talk about this more down the road. But cross-examination is the opportunity that our legal system affords the accused. And children have really paid the price of this adversarial system over the years and over the decades. Some resources that are out there: court-appointed special advocates. This is CASA. CASA recruits, trains, and supervises volunteers who serve as powerful voices for abused and neglected children as they navigate through the court system. So CASA plays a critical, vital role in just providing a host of services to children. The Child Victim Witness Program is offered in Canada. This program allows advocates to work individually with each family. It's important to know, if you're a social worker in a different state, it's important to know what resources you have available. So Juvenile Court was established in Illinois in 1899. It was designed to rehabilitate youth offenders and to protect children. So parens patriae is the Latin phrase, which just literally means child of the state. So we realize that parents oftentimes do a great job until they don't. And when the law has systems in place that when parents do not meet the basic requirements, when they are abusive, when they are neglecting their kids, then the state will step in and serve as their parents for the best interest of the child. Most juvenile cases are juvenile delinquency. So juvenile delinquency is antisocial behavior by a minor that would be punished criminally if committed by an adult. I was called as an expert witness in youth court, where we have 12, 13, 14, 15-year-old kids who are acting out sexually, who are acting out and mistreating 4, 5, 6, and 7-year-old kids. So in this type of delinquency case, this behavior is punished, and it is punished through the court system, through the juvenile courts. Juvenile delinquency is antisocial behavior that would be criminal if it was committed by adults. We also have status offenses. This is an act that is against the law only because the person is engaging in it is a minor. So sexual intercourse by two consenting individuals, people who choose to be romantically, physically intimate, that's not criminal activity unless the child is under the age of consent. So in Mississippi, that is 16 years of age. And so a child who is 16 can't legally consent. A child who is 16 can only consent to sexual activity to someone who is 36 months removed from their age. So that means a 17-year-old and an 18-year-old, and really the law caps it at 18 and a half. So I have conducted forensic interviews in what would become sexual battery cases where an adolescent is involved with someone who is 19 and 20, and this is their quote-unquote boyfriend or girlfriend, and this is a status offense. Dependency cases determine whether the child's needs are met by current guardians, generally the parents, or if the state needs to take temporary custody. You can still find these dependency cases really determining a lot of important steps for the child. And I will say, in a forensic interview setting, a multidisciplinary team, after the case has been established, whether it was resolved criminally or not, we would still follow these cases, sometimes for years. So if a child made allegations and the grand jury decided not to indict, and it did not move further into prosecution, we wouldn't just drop the multidisciplinary team case. It would remain something that we looked at because we were interested in the progression of this child's case. So dependency cases would be something we could staff just to get an update. Detention hearings determine if there is sufficient evidence for the state to hold the child pending further investigation. This is also referred to as the 72-hour hearing. Now the hearsay law, hearsay is against the law. You can't go into court and I can't swear under oath that I heard a rumor about Johnny because that's hearsay. And so what becomes tricky in forensic interviewing is that I did not observe the abuse. I am not a witness. The child is the victim, or the child is a witness, would say alleged victim, that I'm interviewing because I'm allowed to, as an expert in forensic interviewing of children, to help them provide clarification. And this is inadmissible in court without an exception. So there are some notable exceptions to the hearsay law. So if a young child is at kindergarten and it's a 6-year-old child and she's drawing a picture, and she draws a picture of someone it appears to be mistreating her. She's coloring a picture of it looks to be to the teacher as an older man mistreating her. The teacher, let's say, says, "Tell me about your picture," or what are you drawing? The child hypothetically says, "This is," and she provides a name, and she says, "This is him doing things I don't like." Okay, that teacher can then be a witness in court because of the exception to the hearsay law, which is excited utterance. If the child is excited and just communicates this out, almost as if we weren't talking about this, we were coloring, we were having playtime, and the child just made a statement. So as a good mandated reporter, as a teacher, I didn't talk to my principal first, I called CPS because that's what mandatory reporters do. And the CPS worker came to the school and interviewed me. I provided the full statement. She then spoke briefly to the child to make sure that the child was safe. The social worker then spoke to the mother to make sure that the mother has a commitment to protect the child. And so then that teacher could be called as a witness to court under the excited utterance exception. There were other exceptions forensic interviewers would use. So the Daubert standard is, this is a more in-depth discussion that we'll have today, but there are exceptions to hearsay, and we consistently were allowed to provide a witness to what the child told us under these hearsay exceptions. The dispositional hearings, the judge enters their decision as to what is in the best interest of the child, and then review hearings take place approximately 6 months after a care plan has been established. So this takes you through the timeline progression of a child's case. If the mother is not committed to protect the child, meaning if the mother continues to see the boyfriend who is alleged to have harmed their child, and if she is committed to this, then in a permanency hearing, it could be the case where the court decides to terminate parental rights. Now, this is a very, very, very long process. So felony child abuse charges are very serious. They're punishable with imprisonment of greater than 1 year or even the death penalty. And I have interviewed cases where the death penalty was on the table. I will leave it at that. In terms of misdemeanor abuse, I've interviewed cases where the allegation was not felonious, but clearly abusive. And there is a range, so depending on state statutes. I've interviewed children who were the allegedly victims of just inappropriate behavior, people flashing themselves, people exposing them to pornography, both purposefully or accidentally. That's also something that is harmful to children if it's actually part of our neglect discussion that you might remember. An arraignment is the initial step in criminal prosecution during which defendants hear the charges against them and enter a plea. Criminal courts, these are a review of the child's current placement and long-range goals. Permanent plans include termination of parental rights and adoption. I would say that when criminal court happens, when there is a felonious allegation, then we must review the child's current placement and long-range goals. So a guardian ad litem, oftentimes referred to as the GAL, is an adult who is appointed by the court to represent the best interest of the child during court proceedings. This is usually a lawyer. We work very closely with many public defenders who could defend all types of clients, but they wanted to serve as a guardian ad litem because they wanted to help children. And so this is an important role. So the felony statute, criminal statute, is beyond reasonable doubt. This is the burden of proof in criminal court, a doubt that prevents one from being firmly convinced of a defendant's guilt. So it's the highest burden of proof. So jurors must enter their plea beyond a reasonable doubt. So accommodations for children. Efforts are made to avoid further traumatizing children. So what we can do is frequently recess in making the child friendly approach apply to the courtroom. Massachusetts actually set up a child-sized table in front of the jury. This was obviously objected, and it was actually objected all the way to the Supreme Court, and the Supreme Court upheld this. So the federal statute is very clear that our federal government wants to protect kids as they witness crime and as they're victims of crime. And most importantly, research shows, as I said before, they're going to testify more accurately when they're more comfortable and when they're not traumatized. So if you're testifying in court, you need to dress professionally. You need to be objective and sincere. You can't be defensive and combative. You must know your role and stay in your lane. What that means is if you're not specifically listed as an expert witness, then you are a fact witness. So you do not share your professional opinion. It just so happened that with my master's degree and the extensive training that I had, that was part of the role. That's part of the gig as a forensic interviewer. So you're going to testify as an expert witness. And that means you're going to open up yourself to the hardest line of attacks. And so that really put us on our toes. It put us on our game in order to go to that extra training. And we went to trainings from Orlando to Hollywood. We would even sometimes volunteer to run some fundraising for large child abuse groups so that we could get access to education. So there's always a way for you to work hard to be well qualified. You shouldn't be scared of being licensed, or you shouldn't be scared of being certified as an expert witness if you have the training and if you do the work. Preparing for cross-examination is really important. We would go through mock interviews. We would know the weaknesses of our own interview. We would know our own mistakes. And when necessary, you'd have to fall on your sword. I learned that direct phrase from Corner House Child Advocacy Center in Minneapolis, Minnesota. And one of our trainers was named Lori, was a pioneer in the field, and Lori would always say, fall on your sword. But you can prepare ahead and know your weak points, and you can always turn your weaknesses into a positive. Or you can always say, yeah, I would have liked to have phrased this differently, but in hindsight, the child did correct me, the child did clarify themselves, and I reinforced that, and the child then was able to provide a clear accounting of their experience. And so that always enables you to put the child first. Okay, so I wanted to just to share my heart for forensic interviewing, my admiration for those who are in the field. I lasted about 4 years, and then now I find that I'm still able to share my appreciation for the field through lectures like this. So I'm interested to hear about your take on forensic interviewing. Perhaps you want to go into law and you want to maybe pursue being a guardian ad litem. Right? Perhaps you're a child social worker in training and you really want to know about the multidisciplinary team. So I want to just be here and available. I look forward to hearing your responses in the discussion board as always. And thanks for your attentiveness. Take care.